Hi drivers, this video is specifically for those of you who are owner-operators or so-called lease purchase or leased contractors. So the DOT has regulations that say there must be a lease with somebody who is a truck owner who is leasing the truck to a trucking company. The regulations use the term authorized carrier. I like the term trucking company better. Also, if you're a lease purchase driver, so-called, or leased driver, you've been naive enough to enter into one of those cons, then the owner-operator lease regulations apply to you also. So if a trucking company or trucking company affiliate in Chicago, the four-truck operation has conned you enough into, and you've been naive enough to accept the con, enter into the con, and they lease you a truck to you, you have to have a lease of the truck back to the trucking company. So there is a lease requirement that where you're leasing a truck to a trucking company, contracting to it, there has to be a written lease and it has to have certain provisions. So the DOT has regulations that say these items must be in a lease of a truck to a carrier that is going to be personally operated by a driver. And so it doesn't prohibit other stuff, but it requires certain things to be in the lease. And one of the things that has to be in a lease is a term stating payment, when payment will be made. And the payment term cannot be less or greater than 15 days after submission of trip paperwork, such as logs, delivery receipts, particularly those things that are required for the carrier to get paid by the shipper, the receiver, or the broker. So one, the lease can say and that the carrier can withhold payment for because the driver has not submitted the logs and two documents necessary to secure payment from the carrier's customer. And the lease rules say that the lease can't provide a payment longer than 15 days. So typically a lease will say 15 days, not later than 15 days, because that's a legal requirement. They could say not later than 7 because that doesn't break the law. But typically they'll say not later than 15 days after submission of trip paperwork and logs that the carrier will pay. That's required to be in there. Now there's another, and that is in 49 CFR 376.12F. If you Google that, you'll find it. Payment period, lease has got to provide a provision not longer than 15 days after submission of trip paperwork and logs. And if they don't comply with those regulations, that regulation, the carrier doesn't comply, they're paying you in 21 days. They have violated the truth in leasing regulations. You do have a right to bring a private lawsuit to enforce those regulations. Now, escrow accounts is a whole different matter. The escrow regulations are at 49 CFR 376.12K, and these are escrows with lease contractors or owner-operators. Lease contractors, as to an escrow can be there as to the lease they have with the carrier they are leasing to, not from. And there's technically a distinction. If you're leasing a truck from somebody, if you're going to drive for somebody, you have to have a separate lease, or the lease has to have those same provisions in there. You're leasing it from the XYZ trucking company in Bolingbrook, Illinois, with 3 trucks, and maybe they don't even speak English. And then if you're leasing it back to them, those provisions have to be in the lease or in a separate lease. You can't lease a truck from somebody without leasing it to somebody unless you've got your own operating authority. Now let's talk about escrows. Owner-operator escrows are subject to a 45-day payment period in the DOT's truth in leasing regulations. So the escrow is basically there. the lease has to state what the escrow applies to. And the company has to give you an accounting upon demand of your escrow and of any disbursements from the escrow, and has to state what they can be applied to, what the escrow payments are. And the lease rules have to state that they'll pay you interest, that the lease has to say that you're going to be paid interest, and the regulations provide the rate. We don't need to go in that now. The escrow payment is subject to, or the escrow return is subject to a 45-day payment period. Not your settlements. If you're fired as an owner-operator or so-called lease contractor, they're not allowed under the rules to withhold your regular compensation. That's not part of an escrow. They are required to pay you within 15 days of submitting the trip paperwork. They can withhold the escrow for up to 45 days and then make deductions that are specified in the lease, but not with your regular weekly or bi-weekly settlement payment. So escrows, not later than 45 days. Settlements, not later than 15 days after submission of the trip paperwork. I know a lot of carriers will withhold everything, and they're going to charge you. If you're doing a lease purchase with some of these smaller companies, these crooked companies, there's a lot of them in Chicago, but they're an area, but there's a lot in other places too. If you're doing a so-called lease purchase, and I don't need to repeat myself, you watch the videos, you see that I recommend against them. But they'll often tag you for, a dent, a cleaning fee, an oil change, lots of things that may not be permitted by your lease. But escrows need to be returned within 45 days, less deductions, plus interest, and settled. The regular weekly compensation for owner-operators has to be made not later than 15 days after submission of trip paperwork needed to secure payment from the carrier, and your submission of your logs, which of course is done by e-log in most cases now. Thanks for watching. I hope you're not confused.